Welcome to the Justice Journal podcast. I'm Sacramento County District Attorney Anne Marie Schubert. I hope you enjoy this podcast series where we discuss important public safety issues and provide insight into who we are as an office and what we do both in the courtroom and in the community to provide the highest level of public safety through prosecution, prevention, and innovation.
In our last episode, we gave the background and history of the Richard Hirschfield cold case prosecution. I'm joined again by Don Bladet, the lead prosecutor, and Ron Garverick, the investigator on the case. Today, we're going to pick up from after a DNA hit was made through the National DNA Database. Let's talk about now we have a DNA hit, where that took the investigation from there.
Well, because the hit matched to this suspect in Washington named Richard Hirschfield, they go back to the originating agency, which is Sacramento County Sheriff's Department, who had the case and where the two bodies were found. And they're notified by Department of Justice. You receive a form letter, you receive calls, and then they begin to look at the case again, open it up, if you will, because, all right, all of a sudden you've been handed, it's literally a gift. And you say, okay, this is your case, and now this is the guy that did it. Now go back and work it up so you can get an arrest warrant, and so you can get whatever additional facts you can get to help prove the case, because it's going to go to trial. I mean, we're done here.
So the DNA was just the beginning, essentially.
I want to say it's the beginning, and we're going through a case now. Yeah, it's the beginning, because you don't know anything about this person. He was not from the area. He's from a town called Colusa, which is about 2 counties north of here, still in the Central Valley. And he's in custody up in the state of Washington for a couple of child molests. So, you don't know, this guy's he's not on the radar anywhere. And so they begin to work it. They begin to try and put a case together. And having worked because I used to work homicide sheriff's department, you try to get enough to get information enough for an arrest warrant, and then you take it to the person that sits, the gatekeeper, district attorney, the gatekeeper, and at that time was a guy by the name of John O'Mara, greatest brain, one of the greatest brains I've met, because of experience based, and they either approve it or they don't. Well, that's your only game in town. You don't take it to anywhere else. You have to get his approval. And, of course, the district attorney's office is always very selective. And they asked, okay, you've got this DNA hit, but there's more that we need. And so the team at the time was a guy by Ed Newton and Dan Cabral were the 2 detectives, and they were given basically a long list of things to gather, and do before the district attorney's office would give them an arrest warrant. And they worked on that for several months, and that did take several months, but they're doing this in addition to whatever cases they have that are coming in. So I'm sure people at the district attorney's office are going, hey, we gave them that list 2 months ago, what's going on? And it's like, well, we're busy, we've got all these new bodies coming in, we can't get to it. And that's where the focus began to work and look at Richard Hirschfield, a name that nobody had ever heard before.
What did you learn about who he was?
We learned he was a sexual deviant. We learned he had a lot more connection to the areas that were pertinent in this investigation than thought. And a lot of that, he won't say it because he doesn't want to talk about himself, but Ron did the legwork on. He went up to Colusa. He found family members. He interviewed teachers. He interviewed friends. He got an entire timeline from when this individual was born until the day he was arrested to get the background on Richard Hirschfield. What we found out was he had, in fact, committed a sexual offense very similar to this case shortly before this crime happened. And on April 30th of 1975, he went into an apartment of Margaret and her sister Michelle, who had her boyfriend there. They were teenagers. Margaret was 22 and newly married. He threatened them, tied them up, had a box cutter, a garrote. He had a gun in his hand. He asked who wanted to be raped. And Margaret didn't want her little sister to be raped. So she said, please don't hurt her. Take me. And he did. And for that crime, which was a burglary, which was a rape, which was an attempted rape, which was essentially holding them prisoner in their home for quite some time while he ransacked the place. In 1975, sentencing and crime treatment was different. He was sentenced to 7 to life, so he was eligible for parole in a short amount of time. And actually, he ended up being released in June of 1980, just months after he was convicted of this, and about 6 months before he committed this crime. So we found out that he had committed a very similar crime with both male and female. That was another unique aspect of this case, was that a couple was involved. It wasn't just a female who was targeted. So we found out about the Mountain View crime, and then we found out that he had been released from prison in June of 1980 and was 31 years old. He was 6 feet, 240 pounds. He was a big, strong guy at the time. And he was convicted of 12 felonies there and still was out within 5 years and was out to commit the crime that he committed here, this horrific case. What was in his history that allowed us to find him was what he did in 1996. He was in Washington and he sexually assaulted a 9-year-old little girl and an 11-year-old little girl at a water park in Washington. And he fondled them under their bathing suits, unbeknownst to their parents at the park, and was convicted of those offenses. Frustratingly, during the legal process of that case, after he was convicted and imprisoned, that conviction was actually overturned because he was one of those people that manipulated the legal system, wanted to be his own lawyer, then changed his mind, and was kind of toying with the system to his advantage. And an appellate court in Washington decided that he should have been able to be his lawyer, so those convictions were overturned while we were pending trial in this case. So there were a number of things that happened that were very unique in this case. But what we did learn was this is who he is. He's a sexual offender. Ron ended up finding out about all of the molest and sexual offenses he committed within his family as a younger person, through decades, the victims, dozens of victims, through his lifetime, reported and unreported. That's who he is.
How do you go about preparing and building a case, given the history and all the information that you found about him?
Well, as far as preparing the case for trial, what this case posed a number of different difficulties. One of the main unique difficulties is very rarely is it that another DA's office has essentially prepared an entire capital case against different suspects. So the defense had a ready-made defense prepared by a DA's office and law enforcement. That case had been active for years. So what all the paperwork involved, the transcripts, the investigative materials, the court hearings, all of that information had to be brought to Sacramento County. All the 1980 original investigative materials had to be looked at and documented. And then we, of course, did all the new investigations. So in the end, there was over 200,000 pages, 80 banker boxes of materials in this case. But what it came down to, the biggest difficulty was the treatment of the evidence over the decades. So we had to find people who could establish our chain of custody for that critical blanket. For autopsy slides, there was a slide that was critical in proving one of the allegations, which included an oral copulation allegation in the course of this murder, with him forcing Sabrina to perform that act. The reason that charge happened was because we had detected a sperm on an oral swab that had been taken from Sabrina. It wasn't enough to do a DNA profile, but it certainly showed very clearly that there was sperm in her mouth. And that item of evidence, again, when it was first looked at decades before, there had been fading of a dye that prevented the analyst from seeing it on initial inspection. So we had to explain a lot of those things and the changes of technology and things that a jury would expect in 2012 weren't necessarily what was happening in technology and in crime labs in 1980, 1990. So those were some of the obstacles that we faced. We also, of course, Ron knows in investigating cold cases, there's a lot of witness issues you run into.
There are tons of witness issues. I'll talk about a couple things, though, real quick. When you get these DNA cases, you mentioned at the beginning, well, this is just kind of the start. And it's been my experience when you work a case like that, a jury does not just want to see, and I mentioned it to you, just throwing out some numbers. And in this case, it was like 1 in 240 trillion. I mean, it's great. But you can't just throw that on the table and expect the people in the jury to go, well, okay, that's science, I buy it, I'm done. You kind of have to tell them a story. You've got to tell the whole story, even if you didn't. I mean, the DNA is the best thing and there is, and you can drop it on. It's the lid on top of the box, but you got to have a box and you got to have stuff inside the box. So one of the problems we had with this is Hirschfield's a horrible guy, and everything we found out about him was horrible. And full disclosure, he had a bad childhood. I'm not going to say he didn't. But, you start finding out about these crimes. You start finding about the criminal he was. He was a very smart guy. And it's really displayed in some of these crimes, like when Don talks about the Mountain View rapes. I mean, he brings all the stuff with him. And he then molests kids. And one of the problems we had was we didn't have a connection between Davis and Calusa in Williams area where he's found. So I'd look back through some of the reports and somebody said, we knew Richard. So I went and followed up on that lead. And it turns out he had a friend that lived on a small court called Benicia Court in Davis. And you could stand at the end of Benicia Court and look east about 2 blocks, and you could see the apartment complex at 2025 Alta Loma where the victims were taken from. And so it's like, okay, if I'm his juror, I go, okay, now I know how he got that. He just didn't stumble upon this, because what you have is he takes their van and kidnaps them, and then he ends up over 40 miles away just about in Folsom. Well, how does he get back? I mean, there's a lot of holes in people's minds. Well, he doesn't. He goes, visits his friends, he's already there, and then he can then get in, steals their car, goes them, and then later hooks up with his brother, and that's how he gets back. So there were, the answer was there, but you had a lot of questions in between, and my job's always been to make a case better. And so, it's like, well, what'll fill in the holes? So I was a hole filler.
And one of the biggest holes was finding Hirschfield's brother, Joseph. That gave us a connection to the body recovery site, and it also gave us some powerful evidence, and Ron was there for that.
I want to talk about Hirschfield's brother, but you mentioned challenges with the case given the passage of time. What, in general, with cold cases, do you find more difficult than a case that might have happened a year ago?
Well, first, your witnesses are old. Some of them are deceased. The primary pathologist in this case, Dr. Rooney, was alive at the time of the criminal proceedings in the preliminary hearing, but he had died by the time trial came around, so he was not available as a witness. There were a number of witnesses who were deceased, who were infirm such that they couldn't testify. We had somebody coming in undergoing brain cancer treatment. We had somebody coming in a wheelchair. We had people who had aged 30 years. So you're dealing with the loss of witnesses. Then you have to look at the evidence and the evidence storage. This evidence has been around. One of the biggest things that we had to litigate at trial, because the defense knew if they can get that blanket excluded, that's a win. And we knew that. So we fought long and hard preparing and litigating the chain of custody and admissibility of that blanket. And Ron had a 50-page spreadsheet of where that blanket had been in the last 30 years. And that is incredibly difficult when you're trying to find people who had worked in a locker facility, in 1990 when it happened to be checked out, and try and get them to come in and talk about chain of custody. So chain of custody with old items of evidence, the way they were stored back then versus the way they're stored now, the witness issues with cold cases, the changes in technology, and people's lack of memory about things. They're often testifying from original reports. The way reports were written in 1980 versus now, the way that things were memorialized was very different. So all of those things pose challenges to our prosecution of this cold case.
The cold cases, and I've talked to people at the sheriff's department and talked with DAs at our office, and unless you've got something that happened like 80 has got to be the latest, or the mid-70s, you have a hard time getting everything together, because Don's big hurdle is always getting the evidence in. So you have to prove a chain of custody. So who signed it here, and then put it in this locker, and then who signed it there. You need several links in that chain, and that's really how you guys come down to discuss it, is links in a chain to make that chain strong enough, or else the chain breaks and then the evidence doesn't come in. And that's a huge, huge problem. And so when Don talks about witnesses, it's not just what you would expect police witnesses. One of the police witnesses in this case has died. A lot of the witnesses that were civilian witnesses has died. A lot of the people that handled the evidence have died. So 40 years is a long time. And if you consider by the time you get to work and be a homicide detective, you're 35, 40, 45. In 1980, in 1913 or whenever this finally ends up in trial, you're either here and really old or you're gone. And that's the hardest part, I think.
There's challenges with cold cases, but there's also advancement of DNA and forensic sciences.
Well, this case sort of tracked the development of DNA in terms of the first analysis that was performed was called DQ alpha. It was one of the first ways that we were doing DNA testing. That's the test that excluded the Hunt group. We knew we had a profile from someone who was not them. Then there was this RFLP. Then that testing changed to PCR. Now there's even new, since we tried this case, there are even new means of gathering DNA. It's the same process of getting a DNA profile. It's just the amount of information we get from it now has expounded. And the way that we are able to locate it is different. And we've learned a lot over the decades about the best ways to preserve evidence, the best ways to look for evidence. The fact that this semen stain was missed on more than one occasion originally when it was examined wasn't due to any fault of those who were doing the work at the time. It was really the limitations of what they knew at the time. And it's hard to explain to a jury in 2012, 2013, that they need to put themselves back in that place and not impute the knowledge we have today to what was going on by these well-meaning criminalists back early on. So this also tracks the development of these national databases. We started with our state database. Not every state had one. Then we had the CODIS national database. And it wasn't until we uploaded that we obtained Richard Hirschfield's profile because of that Washington state conviction, which is why it's so critical for us to have those data banks and to have that information, because had we had a data bank in California, Richard Hirschfield would have been in it for that Mountain View rape, and we would have solved this case back in 1980 if we had had that knowledge and that technology. And that's What we have now is such a useful tool, which is important why we need to feed it with information.
We're going to stop our conversation here, and the next episode will pick back up when the trial begins in 2012.
Thank you for listening, and I hope you enjoyed this episode. You can find all of the Justice Journal podcasts on our website at sacda.org, iTunes, Google Play, and YouTube.